What happens when a judge gives you one simple instruction and you completely blow it? Today's case is about to show you exactly why following court orders isn't optional. We've got Miss Johnson, employed at a hospital, wearing an ankle monitor, and about to face a judge who's already given her a second chance. But here's the twist. She forgot to do one critical thing that could send her straight to jail. Her father's in the courtroom. Her lawyer's scrambling, and the judge? He's about to reach his breaking point. This isn't just about missed appointments. It's about whether someone who's been given every opportunity deserves another chance. Buckle up, because what happens next will have you questioning everything about our justice system.
Please state your name for the record, ma'am.
Ayana Johnson.
Thank you, Your Honor. Today is the date and time that was originally set for sentencing. I have received and reviewed the recommendation from probation with Ms. Johnson. She has not, we do acknowledge she has not completed the alcohol screening and assessment through Von Schwartz, and she did miss a test on July 1st. I did discuss this with her yesterday on the phone and advised her to go to community corrections as soon as possible to try to test. She informed me, and so did her father, who is here with her today, that she did go to community corrections this morning before court and was there for about 45 minutes, and they said she was unable to test this morning. We are respectfully requesting that the court not remand her at this time and that we adjourn the sentencing out in August to give her the opportunity to complete the alcohol screening and assessment. She is gainfully employed at St. Joe's. She does not want to lose that job. In the alternate, if the court is inclined to remand her in both speaking with Ms. Johnson and her father, our request would be to potentially allow that remand to happen a couple weeks in the future so she can take time off work at St. Joe's so she does not lose that job. Other than that, Your Honor, we respectfully request an adjournment of the sentencing.
And Teresa Clare on behalf of probation. Your Honor, I did communicate with community corrections this morning. She did go over and she wasn't scheduled to do a test today, so she did not test. She did do her download of her scram. I just confirmed with them that there was no violations on the scram. However, she had not reported to them after June 15th. So there was quite a bit of info that they had to download on that. So I do know that there was no violations on the scram. However, probation also wants to point out to the court that this court did direct her back on April 3rd, I believe, and warned her about any further mistesting. So she was given a warning by this court back in April about her remaining compliant with the testing.
Hold up. Let's break this down, because there's a lot to unpack here. Miss Johnson has two major strikes against her. First, she completely failed to complete her court-ordered alcohol screening. That's not a suggestion, folks. That's a requirement. Second, she missed a drug test on July 1st. But here's where it gets interesting. Her scram ankle monitor shows NO violations. So she's not drinking, but she's failing to follow basic court instructions. The defense attorney is doing damage control. But notice how they're already preparing for the worst? They're asking that if she gets locked up, can it at least be delayed so she doesn't lose her job at the hospital? That's when you know things are about to go sideways. And that warning from April? Yeah, that's about to come back and bite her hard.
Why?
Why what?
Why'd you miss a test? I mean, I gave you a huge break back in April and just told you, just don't miss the test. You remember that, right?
Yeah.
And then when you pled, why didn't you do your alcohol screening and assessment?
Forgot to print it out.
What?
I said I forgot to print it out.
Oh.
Did she just say she forgot to print it out? This judge gave her a huge break. His exact words. And her excuse is she forgot to print paperwork? Listen to the disbelief in the judge's voice. This isn't about being forgetful. This is about taking court orders seriously. When a judge warns you in April and you still mess up by July, that's not an accident. That's a pattern. And in the legal world, patterns of noncompliance can land you behind bars faster than you can say, I forgot. The tension in this courtroom just went from 0 to 100 because everyone knows what's coming next. Would you accept that excuse if you were the judge? Let me know in the comments.
They do so much. I mean, I didn't send you the last time. I'll re-refer to defendant Tuvan Swartz for completion of her alcohol screening and assessment. Young lady, understand something. If you don't do it, and I don't have that alcohol screening and assessment, the only thing that I can really sentence you to is the maximum time. And I don't want to.
Paper?
What?
The paper?
What
All
paper?
the lists on it? What is Von Schwartz?
That's for your alcohol screening and assessment.
Is there somebody I'm supposed to go to? What does that name stand for?
That's somebody that you need to call to set up an appointment so that they can interview you and do an assessment.
Okay.
And Your Honor, my office, I know that the clerk's office sends things out. My office also sent an email to her on June 5th, which gave her the packet and the information for the alcohol assessment in addition to the information to complete the victim's impact.
Wait. She doesn't even know of on Schwartz IS. This is a place she was supposed to go for her court-ordered alcohol assessment. And she's asking what it stands for? They sent her the information on June 5th. That's almost 2 months ago. The judge is literally explaining to a grown woman, step by step, what she was supposed to do. And here's the kicker. Without this assessment, the judge can only sentence her to the maximum time. He's spelling out the consequences right to her face, and she seems completely lost. This isn't just negligence. This is a masterclass in how not to handle court requirements. The frustration in this courtroom is palpable, and honestly, I'm feeling it too. How do you not know what you're supposed to do after 2 months?
Need to pay a $75 referral fee. Do you have that?
No.
Adjourner sentenced at August 28, 2024, 9 a.m. Young lady, you are leaving me with no options. And I have a feeling that if you don't follow this, that I'm going to end up sending you for the maximum time. I don't want to do that. I'm going to end up finding you in contempt and sending you. So in this, I'm going to, for the bond violation, I'm going to remand her for 3 days. Washtenaw County Jail for the bond violation. Defendant's remanded. Just go. Is that Dad?
Yes, Your Honor.
Get her back. Dad, hang on one second. Go ahead, take her back.
And there it is. 3 days in county jail. Immediately. She doesn't even have the $75 fee. And the judge has had enough. Notice how he says, "You're leaving me with no options?" That's judge speak for "you've pushed me to my limit." But here's what really gets me. He rescheduled her sentencing to August 28th, giving her another chance, but she's going to jail right now for contempt. And then, plot twist, Dad's in courtroom. The judge literally tells him to get her, and suddenly realizes her father is there. This is about to get even more dramatic, because now we got a parent watching their adult child get hauled off to jail. The judge calls Dad up to the bench. This never happens unless something significant is about to go down.
Her back. Come on up, Tito. Can you come up to your phone? What's your name, sir?
Tony Johnson.
Okay. Can you help try to get her through the,
Yes, I will definitely make sure that she does it. She lives with her mom, so I don't kind of know the things that kind of goes on. So I'm just coming to support, and I just was hoping that you didn't take her to jail because
I
she
know,
need this job so bad.
I know. And trust me, I did not want to. Miss Clara, can you give to Dad the Von Swartz information and the victim's impact information so that he has it, so that I get where he is. So that he knows what she has to do.
Yes, Your
So
Honor. I do know, I heard him in the hallway, really getting after her for not doing things. So I think that he will.
Well, I don't doubt
If
that.
you stop by my office, or I'll ask them to give you the paper printed out.
And is that in this
It's
building?
right down the hallway.
Okay.
And so I'll tell them you're coming right down.
And,
Okay.
I have the $75 for any fee or whatever that she might have needed to pay. I do have the money, so.
This is heartbreaking. Dad's here with $775, not just a $75 fee, but 10 times that amount, ready to pay whatever it takes to help his daughter. He admits he doesn't live with her and doesn't know everything that's going on, but he's here. The defense attorney overheard him getting after her in the hallway for not completing her requirements. Even the judge says, I did not want to send her to jail. But here's the harsh reality of the justice system. Good intentions and supportive parents can't undo repeated failures to comply with court orders. The judge is now giving Dad all the information his daughter should have handled months ago. It's a last-ditch effort to salvage what's left of the situation. Do you think having Dad involved will make a difference when she gets out in 3 days?
Whose case is this? Yours?
Yes, Your Honor.
Counsel approach with Miss Clara.
Let's recap what just went down in this courtroom. Miss Johnson was given a direct warning in April to not miss any drug tests. She was ordered to complete an alcohol screening assessment and given all the information on June 5th. Fast forward today. She missed a test on July 1st, never completed the assessment, didn't even know what Von Schwartz was, forgot to print paperwork, and didn't have the $75 fee. The result? 3 days in county jail for contempt. Her sentencing pushed to August 28th, and a father scrambling to pick up the pieces. The judge made it crystal clear. Without that assessment, she's facing maximum sentencing. This case is a textbook example of how small failures to follow court orders can snowball into jail time and potentially years in prison. Her scram monitor showed no violations. She has a good job at a hospital and family support, but none of that mattered when she couldn't follow basic instructions. The lesson here? When a judge gives you a second chance, you better take it seriously. Because in the courtroom, I forgot isn't a defense. It's a one-way ticket to a jail cell. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments. Would you have given her another chance? And don't forget to subscribe and hit the notification bell for more jaw-dropping courtroom breakdowns. What case should we cover next? Let me know below.